Right, my name's Gary Bog. I'm from the Office of the Privacy Commissioner, and it's my pleasure today to welcome Judge Harvey to our office. Judge Harvey recently retired District Court Judge after 27 years and 7 months, I understand. He's a director of the New Zealand Centre of ICT Law based at the University of Auckland. He has a PhD in law from the University of Auckland, which is pretty impressive. Must have gained it while you were a judge. That takes a bit of effort. And when I looked through some of his publications, once I got past the first few hundred on ICT law and various internet law things, I was somewhat impressed. He's very well suited, obviously, for today's presentation. He did make comments to the Law Commission and was consulted on by the Law Commission, I understand, on the Harmful Digital Communications Act. This is not Judge Harvey's first visit to our office, and we thank him very much for making his time once more to come back, and I'm sure it'll be a most interesting presentation today on the topic of harmful digital communications, unintended consequences. Thank you for coming back, Judge Harvey.
Thank you for that very kind introduction, and good afternoon to you all. The topic is the Harmful Digital Communications Act and aspects of privacy, as you may expect, and what is referred to as the law of unintended consequences. First thing that we've got to understand about the Harmful Digital Communications Act is that it is an example of what we call internet exceptionalism. That is, it is a law that brings different standards and different rules to behaviour on the internet from what is acceptable, what you can do in the real world. So it is a specifically targeted piece of legislation towards the internet, and in particular communications and speech on the internet. So the law deals not with face-to-face communications, but with digital communications. And right now, because this is being live streamed, it falls within the ambit of the Harmful Digital Communications Act, because it is in fact a digital communication. As to whether or not it is harmful is yet to be seen. It sets out 10 communications principles, and I will talk about those in a little while, and establishes 2 criminal offences and also what I refer to as a civil enforcement regime, together with a little known safe harbour provision which operates in the informal space rather than within the court space. So what are we talking about when we talk about digital communications? Any form of electronic communication. And that includes text, it includes messages, it includes writing, it includes photographs, pictures, recordings, as long as it is communicated electronically. So the electronic element of communication is what matters. The Act deals with harmful digital communication. So what in fact is harm? Harm is defined in the legislation as serious emotional distress. And that is a pretty big umbrella when you think about it. But distress is not enough. Being offended, being outraged probably is not enough. The distress must be emotional, and it must be serious. Does this mean that we're going to have to get a psychologist or a psychiatrist along to court every time there's an allegation of serious emotional distress? Probably not. It may well be looked at within the context of how did the particular communication affect my sleep patterns, whether or not I had to go and see a doctor to get some kind of medication, whether or not I was depressed, whether or not I lost weight. A whole lot of other surrounding circumstances may be indicia of serious emotional distress. The Act also governs the posting of a digital communication. Now, we've been doing a little bit of a study at the ICT Law Centre surrounding the criminal prosecutions that have been brought under this piece of legislation. And one of the difficulties that one particular person had getting their head around was that they said they had not posted a digital communication. And what they were talking about, and this was where the law and this particular individual were passing one another in the night, what he was talking about was putting a letter in the letterbox. That to him was posting a digital communication. Of course, that's not how it happens. Because when you post a digital communication, you are transferring, sending, posting, publishing, disseminating, whatever means you use to communicate information by means of a digital communication, any information at all. And that information may be truthful or it may be untruthful, and we'll talk about that in just a little while. It also includes, specifically, an intimate visual recording of another individual. That is an intimate recording that is taken either with the consent of the individual or without the consent of the individual. So it may be a consensual visual recording. And posting a digital communication also includes attempts. So if you attempt to post a digital communication, you're caught within the definition of posting a digital communication. So, what about the communications principles? These are pretty important. They serve as a big umbrella for the whole legislation. Digital communications and communications under the communications principles should disclose personal facts, sensitive personal facts about an individual. They shouldn't be threatening, intimidating, or menacing. They shouldn't be grossly offensive to reasonable people in the position of the affected individual, and they shouldn't be indecent or obscene or used for the purposes of harassment or make false allegations or contain matters that are in breach of confidence or incite or encourage others to send messages that may be harmful. Or they shouldn't be used to incite people, of course, to commit suicide. And they shouldn't denigrate people, and these are the human rights principles. They shouldn't denigrate people on the basis of race, colour, ethnic, national origin, religion, gender, sexual orientation, or disability. These are the communications principles. What are they? Actually, what they are the rules for polite conversation. These are the sort of things that you should not be talking about in polite conversation. These are the areas of conversation that you shouldn't be talking about, be it in the digital space or in the real world space. That's the way that I like to look at them. When we look at some of these communications principles, we get a clue as to what some of the background to the legislation was. Because when all of this came into effect, the whole process started in about 2012, there had been a considerable amount of publicity about young people being involved in suicidal ideation and also cyberbullying. So the thrust of the legislation was against cyberbullying primarily. That was the way in which it was put out there, together with dealing with issues surrounding suicidal ideation and the way in which digital communications are being used to encourage people to do away with themselves, which was an extremely unfortunate sort of thing to be doing, but something that had to be addressed. So that's one of the reasons why you've got a particular thing about suicide, for example. So where are we at the moment? Well, although we've got the law that's been through Parliament, only part of it has been commenced. The offence of section 22, posting a harmful digital communication, the criminal offence has in fact commenced. And that's in place now, and I'll talk about that in a moment. The safe harbour provisions are also in effect. And some of the other consequential amendments that have been passed to the Harassment Act, and the Human Rights Act, and the Privacy Act, and the Crimes Act have also been enacted, together with the interpretation of the communications principles and so on. The civil enforcement regime has not yet started, and that will be coming into effect in November, and that requires a special order in council. So let's look at the three areas: the criminal offence, the safe harbour, and the civil enforcement regime. The criminal offence is under section 22, causing harm by posting a digital communication, and the elements of that offence are that there has to be a digital communication posted with a specific intention, and that is an intention that it causes harm, that is serious emotional distress to the victim. The victim is the targeted individual of the communication. The second test that you look at is, was the communication one that would cause harm to an ordinary reasonable person, which we'd call the objective side of the argument, in the position of the victim, which is the subjective side of the argument. So you take an objective point of view and you say to yourself, okay, now what were the particular circumstances surrounding this particular victim that may modify what the ordinary reasonable person might think? And then finally, there has to be actual harm. Posting of the communication caused actual serious emotional distress to the victim. Now, it may well be that the situation, if you came face to face with a person and said something horrible to them, that would not be an offence unless, of course, you were threatening them with physical harm. But doing it online puts you into an entirely different category. And that's why this is internet exceptionalism. So what is the court going to look at when they're considering a prosecution under Section 22? Well, how extreme was the language? Some of the language can get pretty extreme, believe me. We've been doing some research on this at the centre. We've been gathering together some data on fact situations about some of these harmful communication prosecutions, and the language is pretty extreme. Age and characteristics of the victim might be a little bit different if you had somebody who was vulnerable or somebody who was young. Was the digital communication anonymous with somebody hiding behind a nom de plume? Was the digital communication repeated, and if so, how often? Because dissemination on the internet is a factor that has to be taken into account. And that is related also to the circulation of the communication. Was the communication true or false? Because remember, a digital communication may be true or it may be false. And what context was there to this particular communication? So there are a number of factors that a court is going to take into account. When we talk about defamation, for example, or when we talk about information that may be harmful, we generally are able to say, well, it's true. It may be unfortunate, but it's true nonetheless. And the legislation allows the court to take that into account. Posting a digital communication, truthful or untruthful. Now, why is it then that truthful information may well constitute a harmful communication? The answer is that there are often truths that we all have within our own private space that we would rather not get out there. I think every family probably has a skeleton in the closet somewhere. I know that mine did. And the question is whether or not that sort of truth is something that should be widely known. And if it does become widely known, what effect is it going to have on the family, for example, or those people for whom it is a private truth? So that is perhaps the answer to whether or not truth should be a defence. The truth hurts. It's a saying that we all know. It can, of course, be that the truth causes serious emotional distress. So that's the criminal offence. And just to sort of round off on that, the Law Commission, when it suggested a criminal offence, suggested that it would be used very rarely. It would be an extremely rare situation for a person to be prosecuted under their proposals of Section 22. Well, they might have got that wrong, because since the legislation was enacted in July of last year, there have been up to 60 prosecutions brought under Section 22, with sentences on the guilty pleas that have ranged from 11 months imprisonment all the way through to a discharge without conviction or diversion. As yet, there haven't been any defended cases that have gone ahead. The one or two that did go, or that were listed for hearing not so long ago, settled, they resolved before the matter got to a hearing. So we haven't yet had judicial consideration of what really amounts to serious emotional distress or harm under the legislation. And the fact is, haven't had an opportunity to be judicially aired. But I understand that there is a case coming up next week, which will be going ahead, and we'll see what happens with that one, and I'll be keeping an eye on that. So what I want to do now is I want to pass to the safe harbour provisions, and these are what I call the informal provisions of the legislation, because they don't involve a court of law. And I've suggested that this may well be a shortcut to censorship, and in that respect is probably an unintended consequence of the legislation, because the legislation was, after all, aimed at cyberbullying. The safe harbour provisions provide a safe harbour or protection from criminal and civil liability for an online content host. And an online content host is the person who has control over part of an electronic retrieval system like a website or an online application upon which a communication is posted and is accessible by the user. Now, online content host covers a whole bunch of people, from Google through to a blogger or somebody who owns a Facebook page. But the fact of the matter is that there is potential liability, criminal and civil, for a digital communication that is posted up on a site that is hosted by an individual. There have been cases involving Facebook in that regard. So what happens? Somebody sees content that they object to and they get in touch with the online content host and complain. The online content host then notifies the author. Somebody's complained about the content that you have posted. You have some options. You can do nothing, you can consent to it being taken down, or you can object to it being taken down. So the author may file a counter notice saying, I don't have any objection with this being taken down, take it down, remove it. The content goes. Just like that. Now the complaint normally has to state things like serious emotional distress or breach of a communications principle, but you see the online content host doesn't carry out any evaluation of that at all. All it has to do for the complainant is to state it, whether it's true or not, whether it fulfills the definitions or not. And the online content host, to protect him or herself from liability, has to do something about it. So the author consents to removal, down it goes, out the window, it's gone. The author files a counter notice saying, no, I don't consent to this, it stays. But the online content host is protected. Even although they're aware of it being published, they've got the safe harbour because they've done what they ought to have done. And then, of course, the author and the complainant can fight it out in another location. If the author does nothing within 48 hours, the online content host, to obtain the benefit of the safe harbour, has to take the material out. So once again, there it goes. So you can see why I call it a shortcut to censorship, because there's no evaluation whatsoever of the validity of the content or anything like that. And this could well be used, I would suggest, as a fast track to a takedown. And I don't think the legislation was intended for that, because there's no evaluation of the content. It's certainly a shortcut. And an issue is whether or not, by removing the content, and we're not talking about de-indexing, which was the situation in the Google Spain case, we're actually talking about removal of the content. Is this a way in which some people could informally enforce a right to be forgotten? And I suggest, in fact, that it is the right to be forgotten in the Google Spain case on steroids, because it relates to source content. So, what about the civil enforcement regime? We've talked about the criminal side of things. We've talked about the safe harbour. the civil enforcement regime is a regime that is in place that is remedial. It doesn't involve any claim for damages. It doesn't involve any claim for compensation. It provides a remedy for the posting of a harmful digital communication, and it runs parallel to the criminal offence, because a criminal offence could also qualify for treatment under the civil enforcement regime. The way in which the legislation is structured places the power in the hands of the district court to make certain orders, and I'll get on to that in a moment. And those orders are there under Section 18 and Section 19 of the Act. But importantly, absolutely critical to the process is that you cannot make an application to the district court for a Section 19 order until you have gone to the approved agency established under the Act, and they've got to have a reasonable opportunity to assess the complaint. Now, the approved agency is NetSafe, a well-known organisation within the digital space here in New Zealand, and the approved agency is critical to the process. They receive the complaints to start with, and they investigate them, and they evaluate them, and they consider whether or not there's something that can be sorted out or resolved between the parties using advice and negotiation and mediation and persuasion. So it's an opportunity to resolve the problem without the necessity of getting involved in the formal court process. In addition, they have an obligation to maintain relationships with offshore providers like Facebook, Twitter, Instagram, and so on and so forth, and other online content hosts. They're statutorily obliged to provide education and advice on online safety and conduct on the internet, which is something that NetSafe has been doing since the get-go. And then they've got to perform any other functions that are conferred upon them by the legislation. So, in essence, NetSafe, or the approved agency, is a filtering system. Disposes of complaints, makes evaluations of them, sometimes may say, this is vexatious, there's nothing in this, we're not going to investigate it any further. It's frivolous, it's trivial. Yes, you're offended, but offence is not serious emotional distress. It may well be that the complaint isn't the type of complaint, the content isn't the type of content that's going to cause harm to an individual, or it doesn't contravene communications principles. The agency has the opportunity to make those evaluations. But if they say, sorry, we can't do anything to assist you, they've got to tell them that they do have a right, the complainant does have a right, to go to the court and seek an order. So when you make your application to the court, you may be an affected individual, somebody who's affected by the communication, who has suffered, past tense, or will suffer harm from a harmful digital communication. So there's a retrospective aspect to it and there's a prospective aspect to it. Parents or guardians may make an application on behalf of children. School principals may make an application. The police, if there's a safety threat to the affected individual, and in certain circumstances the chief coroner. The applications have to be in writing, they have to conform with the rules, and the rules are presently going through the process of enactment and will be available by November when the civil enforcement regime comes into effect, and there is no filing fee. Now, the court can't make an order until it's satisfied first that there's been a serious breach, or a threatened serious breach, or a repeated breach of a communications principle, and in addition that the breach has caused or is likely to cause harm to an individual. The court may have a look at the proceedings and say, well look, there's nothing in this, it's frivolous or vexatious, or it doesn't hit any of the thresholds, it doesn't breach the communications principle, and dismiss the application. It may dismiss a police application if it considers that the application should, under the circumstances, be dismissed. In addition, before the court goes through to the process of making an order or considering an order, the court may refer the matter back to the approved agency to see if there's a possibility, another go at trying to resolve this. Unless, of course, it's not really going to do any good. It's not going to contribute to the resolution or be in the public interest, or it might undermine proceedings already before the court. In addition, the court may ask the approved agency to provide some information which could be rather helpful in working out what the real issue and dispute between the parties may be, because it could well be that through their mediation process, the approved agency's been able to get agreement on every part of the dispute except for one. It may well be that by identifying that one problem, the court can cut through and make the necessary orders or see if there's some other way of resolving it. I said that damages aren't a remedy. Under Section 19, the first thing that a court can do is order that material be taken down. And once again, we've got the content being taken down, not de-indexed, but actually taken down. So once again, we've got a potential right to be forgotten situation arising here, except that the court has to carry out an evaluation and consider whether or not the communication falls within the ambit of the Act. It may make a restraining order that the defendant cease or refrain from the conduct that is concerned. So a restraining order, you will take the content down and you won't put it back up again. And furthermore, we order that you're not allowed to encourage anybody else to put the stuff up there either. Mustn't encourage other people to engage in similar communications. Oh, and by the way, your communication was untrue, so we're going to ask you to publish a correction. Although I'll bet that the court will be writing the correction, because it could well be that if you leave it up to the defendant, they might just continue the harassment in another way. The affected individual might have a right of reply, and also there is the right to order an apology. But once again, I don't think that it should be the defendant who writes the apology. So that's against the author. Section 19, subsection 1 is against the author of the content. Court also has the power to make an order against the online content host to take down or disable public access to material that's been posted or sent. And when you talk about disabling public access, now you're getting into the de-indexing area. Or alternatively, if the online content host knows who the author is, who's been publishing under an anonymous handle, then the court can order that veil of anonymity be stripped aside and the individual be identified. Also, the court can order an online content host to publish a correction or a right of reply as well. And then finally, the court has the power to make orders against an IPAP, which is a complicated term for an internet service provider, that the identity of the anonymous communicator be released to the court, because your internet service provider will have logs of who the customer was who was using a particular internet protocol number at a particular time, and that information can be made available to the court. If other people have been engaged in spreading the harmful communication, the court can make orders as far as they are concerned. The court can also declare that a particular communication breaches a communications principle, and it may make suppression orders, may order that the names of the parties be suppressed. And when the court is considering its Section 19 orders, the court takes into account the content of the communication and the harm that was caused. Why was the communicator doing this? Was it intended to cause harm? What was the context? What was the subject matter? What were the circumstances of the communication? How far beyond the original parties to the communication had this extended? How old or how vulnerable was the affected individual? Because you don't have to be young to be vulnerable. You can be vulnerable at any age. Was the statement true or false? We've got the truth or falsity issue coming in as well. Was the communication in the public interest a factor that can be taken into account? It's not a defence, just a factor. What had the defendant done after the communication perhaps to mitigate it? Or had the defendant poured petrol onto the fire? And what was the conduct of the affected individual or the complainant? Was this a flame war that was going on between these two people? What are the technical and operational aspects of making the order? Are there going to be any problems in that regard? And the court is able to call upon the assistance of a technical advisor. And who is the appropriate person who should be the subject of the order? Is there somebody else lurking in the background here that we should be interested in? So that, in a nutshell, is the legislation. The three areas: the criminal offence, the safe harbour provisions, and the civil enforcement order. I've said there are unintended consequences. None of the prosecutions that have come before the court that I've been able to investigate would amount to cyberbullying within the terms of that, within the definition of that term that the Law Commission used. What are they about primarily? Well, with one exception, they're all in the context of relationship breakdowns. All in the context of somebody's got some photographs that the other one wouldn't want to be seen on Instagram and they're going to publish them, or something of that nature. Or alternatively, compromising photographs have been sent to somebody's mother, or something of that nature after the relationship is broken down. And again, there's a context also of protection orders under the Domestic Protection Act or under the Harassment Act. So as far as cyberbullying is concerned, in the way that the Law Commission saw it, that hasn't happened. Certainly, the legislation can be used to take down material that is going to do your reputation harm, as long as you can establish that it was in breach of a communications principle and it's causing you serious emotional distress. You're within the umbrella of the legislation and you can use it to adjust your reputation, rather than wait for 2 or 3 years to bring the matter before the High Court in a defamation claim. The problem about the truth could well raise some issues about whether or not this legislation could be used to obtain a right to be forgotten by stealth. And then, of course, you've got the situation where internet exceptionalism rears its ugly head, where there may be a harmful digital communication that appears in an online newspaper that could be taken down, or that somebody has invoked the safe harbour and the newspaper takes it down, but it's still available in print. It's still available on the newsstands in hard copy. Another aspect of internet exceptionalism is the differing standards of speech. What you can say in the real space may be criminalised in the digital space, simply because it's a digital communication. And the problem that you have there is what is going to happen when a person or a group of people start to take offence at something that has been published in a newspaper or in a magazine or something like that, a la Charlie Hebdo in France. There is a right, of course, of free speech and free expression, and that has to be taken into account in all cases under the Harmful Digital Communications Act. But is this legislation going to be used in that way? We're going to have to wait and see, because as yet the Act is still in its infancy. A lot of criminal prosecutions. We'll see what happens when the civil enforcement regime comes into effect in November. So that's all that I want to say about the Harmful Digital Communications Act. Thank you for your attention, and I hope that you're a little bit better informed about this interesting and not uncontroversial piece of legislation.